Hello everyone, welcome to this, our online version of Lee Thompson's clearance seminar, The Lowdown on Clearances. My name is Mike Brookes. I'm Head of Content Clearance and Media Disputes at Lee Thompson. I'll be talking to you today together with Dawkins, another partner in the group. We're going to talk to you for about an hour, and those are our faces, so you know who we are. Leo will start I will start with an introduction, and then Leo will carry on delving into the law of defamation and privacy. Then you'll have me again talking about general clearance of content, which I will explain in more detail. Okay, so the first obvious question to ask is, why do we get things cleared? Is it necessary to clear content? Well, the short answer is yes, and there are a variety of reasons for this. I mean, in the background, the rationale is that we're aiming to reduce risk, eliminate it if possible, but certainly take informed decisions about including material in your program with the knowledge of the risks involved. And there are various kinds of risk. There's the obvious legal risk that someone whom you feature in your program or whose material you include may take objection to that and threaten a claim against you. There are equally contractual risks. A production company will have given warranties and have provided indemnities to a broadcaster that the material that it's delivering is clean and safe and broadcastable. And then finally, there are risks for the broadcaster as well. They'll have regulatory issues to consider, Ofcom, etc., about the material that they're broadcasting. And if working together, the sort of team behind the content can reduce, if not eliminate, the risks by getting the appropriate content clearance advice, then the E&O insurance will be available to provide the necessary comfort to everyone involved in order to deal with any claims that may get made. So this, with no apologies, is the marketing slide. What do we do at Lee & Thompson? The majority of the clients that we represent in this area are film and television production companies, but we've also done lots of clearance work on the broadcaster side as well, for one broadcaster in particular. Equally, we have advertising clients as well. And the issues and the procedure is essentially the same. That's largely because the procedure that we adopt is a wholly flexible one, subject to the minimum requirements of insurance policies. We'll do as little as much as you, the client, require, in a way that best suits you. Sometimes we'll come in at a very early stage. I sometimes sit down with creatives and brainstorm ideas to see whether it's even doable. And I'll hopefully give some tips as to what can and can't be done, and then the writers will go away and work from that premise. Most commonly, we get involved at the script stage. We'll review scripts and we'll report on them. We try and pride ourselves on simply not just saying you can't include this. We'll try and not only explain why, but we'll also come up with hopefully some helpful suggestions as to what you might do and ways to work around the problem. We can help with completing E&O insurance application material. We're also on call throughout the production. I'm regularly speaking to producers on set when something's arisen to see if there's a way to get around it. We'll also, if you want us to, this is a sort of separate piece of work that we do, we'll also work with your either external or internal clearance person who will have hundreds or if not thousands of queries on a production about the content that is being cleared, mainly props, music, etc., etc. And very often a production company business affairs advisor will be too busy to deal with those queries. So we provide a separate service where we liaise with the clearance person on the sort of day-to-day issues of contractual queries, whether something has to be cleared or not, etc., etc. Whatever the process we adopt, it usually ends with a review of a cut. The consequence of which, hopefully, is that then the production is clear to be delivered and broadcast. So that's the brief introduction over with. I'll hand over to Leo now who'll talk to you about some legal issues concerning defamation and privacy.
Hello, and thank you for joining us. So whilst Mike later on will be talking about intellectual property rights, proprietary rights, I will be talking about rights that attach to people, human rights, and in sometimes in respect of corporations as well. That is the right to reputation on the one hand, which is protected by the law of defamation, and on the other, the right to privacy, which is protected by the law of misuse of private information. So dealing first with the right to reputation. Why is this important? Well, it's important because your reputation really determines how people think of you. And I want you to just step back from whatever your job is at the moment, you know, making programs or working for broadcasters or working for insurers, and think about yourself as an individual person. And your reputation really is everything, because it affects your social standing in society and your future opportunities. And it's really a measure of your influence amongst your friends, your family, and perhaps most importantly, amongst people you don't even know yet. And once damaged, it's really hard to repair. So the right to reputation, fundamental human right, protected by defamation. And then to move to what I always think is a sort of slightly different side of your brain is your right to privacy. And that really covers, under the law of misuse of private information, two things. The right to keep certain types of information private, of course, but also the right not to be subjected to unwarranted intrusion. And I'll speak a bit more about what that actually means later on. Why is that important? Why is the right to privacy important? Because privacy is key to ensuring our human dignity, our safety, and our self-determination as individuals. So another key human right. But of course, neither of these rights is absolute. They both go on one side of the scales, and on the other, you have the right to freedom of expression, which is obviously important to program makers, broadcasters, etc. And so you'll see in the law, there's a balancing effect between the two rights. So before I get into the weeds of the law, which is really important to understand in this context of clearing programs, I thought it would be useful just to discuss the different types of program that we come across, and also think about them in terms of risk and how risk differs depending on the kind of show you're doing. And I've taken these five categories of program from an errors and omissions form, an E&O form. And going through them in turn, live television. So on live television, anything can happen, of course, but it depends. The risk depends on what kind of live television program it is, because of course, if it's you know, a special live edition of the Antiques Roadshow, you'd think, well, that's probably not going to be that risky. But then there's an instance where, for example, one guest on a talk show calls the other one a racist on live television. That obviously creates different issues. Then moving along one, we've got documentary portrayal of actual facts or happenings. Obviously, if you're doing documentary work about real life individuals, real companies, then the risk level will depend on what the documentary is about. But there are current affairs programs, of course, like Channel 4 Dispatches or BBC Panorama, for example, that will often intentionally broadcast defamatory allegations about individuals or companies in the name of investigatory journalism, or expose some scandal or other that might have amounted to a grave misuse of private information had there not been some overriding public interest in publishing that information. So these kind of programs, especially the current affairsy kind of ones, are inherently risky and require more thorough legaling pre-publication. Then we've got the dramatic portrayal of real life people or events with fictionalized elements. And here I'm really thinking about biopics, which are all the rage at the moment. Blonde is one you would have heard of recently, which is a fictionalized take on the life of Marilyn Monroe. There was Elvis, of course, about Elvis, and I think I Want to Dance with Somebody is coming out, which is about Whitney Houston. Now, all of those have one thing in common, which is they're all about deceased individuals, and that's quite important. It makes life easier for the program maker, and I'll explain why in a minute. But we've also done worked on a number of biopics that are focused on real life individuals, real living individuals, I should say, which brings with it its own issues. The Crown is a good example, where you have some living individuals portrayed on screen. And the problem with programs like that, or with these kind of dramatic portrayal programs where you have fictionalized elements, is that script writers might, of course, sex up the truth to make the film more compelling. And viewers are more likely to believe fictional elements of the film or show if they're attached to real life people and events. So the job of the program maker is really to make sure that if they make stuff up, they're comfortable with the risk of doing that. Then we've got fictional but inspired by specific events, occurrences, and or characters. So something, an example of that would be Bodyguard, for example, which was the thriller series about a fictional bodyguard to the Home Secretary. Obviously, it's all fictional, but there is a real Home Secretary, so confusion could occur in that kind of scenario. And then you've got entirely fictional. Even in fictional programs, they can be defamatory if viewers would understand references within the program to be referring to real life people, even if the real person's name is not used, and even if the program's not intending to refer to a real person. So let's take an example where you have, say, a fictional drama that's set in the modern day Conservative Party headquarters. This could potentially defame a real Tory MP if viewers would identify a real person with the fictional Tory MP portrayed in the script. And we'll look at ways of reducing that risk later on. Finally, there are situations where real life individuals are somehow mentioned in otherwise entirely fictional settings. And I'm just adding this on the end, if you like, because a good example of this is Netflix and its show Queen's Gambit, which is, if you've seen it, it's a fictional, if you haven't seen it, it's a fictional drama about the life of a fictional female chess player called Beth Harmon. Now, a woman called Nona Gaprindashvili, who was the first ever woman to be awarded the title of chess grandmaster, filed a defamation action against Netflix in the US, in which she complained of a scene in which a commentator, while narrating a match between the protagonist Beth Harmon and a fictional grandmaster, said that the real Gaprindashvili, who was named specifically in the program, is, quotes, the female world champion who's never faced a man. And Gaprindashvili's lawyers and her lawsuit said that she had played actually 59 male chess players by 1968, which was the year in which the episode is set, and that the program suggesting otherwise was false and defamatory. That case recently settled, and it was based in the US, and everything I'm saying today is grounded and in respect of the law as it is in the English jurisdiction, but it's just an example about how these issues can crop up and how they can cause headaches. So let's take a closer look at the law, starting with defamation and the right to reputation. So first of all, who can and who cannot sue? I've included some people and things on the slide, but it's not. These are just some examples. The key examples, obviously, people who can sue are living individuals, and we also have limited companies because corporations have corporate reputations to protect as well. Who cannot sue? Well, the dead cannot sue, or more accurately, an estate or relatives of a deceased person cannot sue for libel over defamatory statements about the deceased person, except that, I mean, there are some jurisdictional differences, I believe. So in the event of international release, or if you're focusing on a particular jurisdiction that isn't the UK, then local council should be consulted on this point. But as a matter of UK law, the dead can't sue for damage to their reputation. This principle has allowed publishers almost free rein to deal with deceased individuals' reputations. And the example of Jimmy Savile is a good one. He reportedly used libel threats to suppress widespread discussion of his behavior. But now that he's dead, we have a true crime TV series that's being made about him, starring Steve Coogan as Savile himself, and obviously God knows what else has been published about Jimmy Savile after he died. This principle is also really useful. The principle of the dead not being able to sue for libel is useful when introducing fictional elements to a real life story, because you can attach them to a character who is dead. And that's useful in particular if those fictional elements are defamatory of that character. Having said that the deceased can't sue or their estate can't sue for defamation, you do have to give some thought to the relatives of the deceased and their rights. Now, there was a recent or fairly recent European Court of Human Rights decision in a case called ML and Slovakia, where a mother complained about false allegations made about her late son in the newspapers in Slovakia. And the European Court found that the newspaper coverage had been not a breach of the dead son's right to reputation, but a breach of the mother's right to privacy. And the court held that dealing appropriately with the dead out of respect for the feelings of the deceased relatives falls within the scope of Article 8, right to privacy, under the European Convention of Human Rights. That's the case in that those are the circumstances in that case. For something to be held like that in this court, in the courts in this jurisdiction, I think would be pretty out there. But it's something to keep an eye on, and it has led to people saying, well, this is just defamation through the back door, through the privacy rights of the relatives. And if you want to read more about that, my colleague Rebecca Bennett has written a very good article about defaming the dead ? On our website. So groups or classes of people can't sue either unless the group or class is sufficiently small and defined. So, for example, a generalized allegation that all solicitors are crooks, God forbid, all solicitors couldn't sue because the group is too large. That would be ridiculous. If, however, you said that the litigation partners in Lee Thompson, of whom there are 6, were raiding money from a client account, each of us could potentially sue for defamation in our own right, even though we weren't mentioned individually, because by referring to the Lee Thompson litigation partners, people might know who we are, well, hopefully. Then finally, I just want to mention governmental bodies, because this is quite important and it comes up quite a lot. So for public policy reasons, governmental bodies can't sue either. And it is thought, the courts have said it's thought that it would be a serious interference with the right to freedom of expression if the wealth of the state, which is of course derived from its subjects like you and me, could be used to launch a defamation action against individuals because they have criticized, however falsely or unfairly, the way the country is managed. So it's the sort of public policy points there. You shouldn't confuse this, however, with individual ministers. Individual ministers in their own right can sue for defamation. So to give you an example, the Department for Business, Energy and Industrial Strategy couldn't sue for defamation, but Jacob Rees-Mogg, if you called him, I don't know, woefully inadequate and underqualified for the job, let's say, he could sue as an individual, and as he is the Minister, of course, for Business, Energy and Industrial Strategy. So hopefully that distinction is clear. So that's who can and cannot sue. Who can be sued? Well, in the old days, you could sue any person who caused or was responsible for the publication of broadcast of a defamatory statement. But now, because of changes made to the law, you can only sue one or more of what are referred to as primary publishers. And that is defined as the author, editor, or publisher of a defamatory statement. And for present purposes, for the purposes of this talk, we're really talking about broadcaster, production company. And let's say you have someone talking on screen like an interviewee, and they say something defamatory, they could be sued as an individual. So generally, claimants tend to go where the money is, but there might be tactical reasons for joining another defendant on. So, for example, suing both the production company and the broadcaster. That does happen. So what does your claimant, the person who wants to sue the defendant for defamation, what do they have to prove? Well, there are three key things. First, that the words are defamatory of the claimant. Second, that they identify the claimant. And thirdly, that the words have been published. We can assume for present purposes that the words have been published or are going to be published because they're going to be broadcast. So we can forget about that one, and we're going to focus on 1 and 2. So first of all, you have to prove, a claimant has to prove that the words are defamatory. And in this jurisdiction, we decide whether words are defamatory in a kind of two-stage process. First of all, you have to decide what the words mean. Now that might sound like a sort of funny thing to say. Don't we know what words mean when we read them? But you and I and everyone else will have different sort of thoughts, concerns, prejudices when we read something, and the court therefore decides what the reasonable objective reader or watcher of a program, if you like, viewer of a program would think the words mean. It's this artificial construct of the reasonable man. And so the courts will decide what the words mean if it can't be agreed upon by the parties, and it often isn't. And then the question is, secondly, is that meaning defamatory? And what is and isn't defamatory has been the subject of a lot of litigation and judicial attention. But and it's actually more complicated than you might think, or that perhaps it should be. But essentially, what it boils down to is as follows: a statement is defamatory if, when said about a person, it would make reasonable people think less of that person. And I think, we can all get our heads around that. And publication has caused or is likely to cause serious harm to the reputation of the claimant. And serious harm, if it's a company or other body trading for profit that wants to bring a claim for defamation, has to equate to serious financial loss. And this second bit, this serious harm threshold, is great news for would-be defendants, for program makers, for publishers, for broadcasters, because it raises the threshold for a defamation case. The idea behind this test, which was brought in under Section 1 of the Defamation Act 2013, is to weed out trivial claims that really are just a waste of everyone's time. What isn't defamatory is mere abuse, and distinguishing between properly defamatory comments and mere abuse can be quite difficult. So, for example, it wouldn't be, they have to go beyond what you say has to go beyond mere insults. It has to go to the heart of the claimant's reputation. So if you said, I hate Leo, he's a tosser, then someone hearing those words would conclude that you don't like me, but wouldn't necessarily think any less of me because, they haven't really learned anything about me or my character. It would be different if you said, I hate Leo, he's a tosser because he stole my wallet and he regularly cheats on his wife. Those words would be defamatory because there you're saying Leo is responsible for a type of behavior that generally right-thinking members of society think is not okay. In other words, theft and adultery. So there's that distinction there. Other examples of things that may be defamatory, subjects, of course, to satisfying this serious harm threshold would be calling someone a liar, dishonest, that they took a bribe, that they're a drug dealer, hypocrite, negligent, and so on and so forth. Examples for companies, things that might be defamatory to say of a company are, Exco makes dangerous products or, exploits its workers or damages the environment, that kind of thing. So let's say this claimant has proven that the words are defamatory. They have to prove also that the words said in your program identify them, and the words have to identify or refer to the claimant in some way, and it doesn't need to be by name. The question is, would the reasonable man understand the words to be referring to the claimant? It's that reasonable man again. And sometimes factual TV programs, for example, will report defamatory allegations, but they won't report the name of the individual, perhaps, I don't know, because they aren't confident they can prove the allegations are true. And they only give certain details which they hope are insufficient to identify the person they're referring to. Now, this can be quite risky because there may be other information out there in the public domain which leads viewers to identify who the person is, potentially leading to liability for the production company or broadcaster via this process of so-called jigsaw identification. So that's something to look out for. Accidental identification can also be an issue, and it's important to note that the intention to defame, whether or not you intended to defame someone, is entirely irrelevant. So you can't just say, "Well, I didn't mean to defame them, so it's all fine." So, for example, using stock footage of, say, an innocent member of the public walking down a street that's synced to some commentary about violent knife crime might defame that individual if you give the impression that that individual is guilty or under suspicion of violent knife crime. So you have to be careful how you do these things. With fictional shows, we always advise that you get a negative check or a neg check, and that's the process by which a producer attempts to ensure that the names of fictional characters in a script cannot be confused with real life people. So let's say, for example, you had a show with a fictional show with a drama with a character that's a New York-based drug dealer with a very particular sounding name, who is portrayed in a very defamatory way, and your neg check says, well, there's only one or two people with this name in this particular district of New York where the show is set. You might decide to change the name of that character before filming so that you reduce that risk. Now, where there is a risk that viewers might identify real people with fictional characters in a drama, you can also include a disclaimer. So something along the lines, and you see all these all the time, something along the lines of, this film is a work of fiction and the characters and events portrayed in it are entirely fictitious. Any resemblance between them and actual characters or events is therefore entirely coincidental. That's not a get out of jail free card for in terms of defamation, but it will affect meaning. It will affect how people understand the program. So let's say our fictional claimant has knocked it out of the park with stages 1 and 2, and is able to bring this defamation claim. What are our defenses? Well, I've set out some of the key defenses here, and actually these are things that you would often, almost always actually, think of prior to publication. So not once you've been dragged through the court and at the very end, but prior to publication. Now, I put in the first box threshold defenses. These aren't really defenses in the true sense at all. But what I mean by that is that, for example, a claimant has failed to show that the allegations are defamatory of them, or that they cause them serious harm, or that they've been identified. So the things we've just been talking about, and cases are struck out on that basis, that there's no, no serious harm, etc. The mother of all defenses is the truth defense. And this is, it's the main defense to a defamation claim. And the important thing to remember is that in this jurisdiction, the burden is on you, the defendant, to prove that the allegations are substantially true. And, we've just had a very widely published example of this with the so-called Wagatha Christie trial, where Colleen Rooney had to prove that Rebecca Vardy was leaking her private Instagram stories to newspapers. And, that was a classic she said scenario where the defendant was trying to prove the truth of the allegations. You cannot rely, it's important to note, you can't rely on the fact that the allegation has been published before. So it's no good saying, well, we've based our film on this biography, we've got the option to do it, this allegation's been published 100 times before, that's fine. Well, it isn't, because you're publishing the allegation yourself. Although it may, if it has been published 100 times before, it may be commercially less risky if the person who's the subject of the allegations hasn't ever bothered bringing legal proceedings. So there's nothing to stop you making punchy, even defamatory content and publishing it. You just have to get your facts straight first. And this is a lot of what we do in our clearance work involves, going through scripts, going through edits and saying, we think this is defamatory. Can you stand this up? Can you prove it with documentary evidence? And then quickly, just to go through some of the other defenses, there's the honest opinion defense, and that protects statements of opinion, not fact, and sometimes it's very hard to differentiate between the two. So statements of honest opinion that are based on true facts known by the speaker at the time of stating the opinion. So in other words, the opinion must be based on true facts which are provable, and be one which is honestly held by the speaker. In addition, the statement needs to indicate either specifically or generally the factual basis for the opinion. If any of those elements is missing, the defense will probably fail. So it's not a straightforward defense, and it's best not to rely on it if you can, save for in very obvious circumstances. There is then the public interest defense, which is in Section 4 of the Defamation Act 2013. This is of most interest to people making documentaries, for example, on public interest topics. And the thing about this defense is it doesn't matter whether you got it wrong and you can't prove the allegations are true, if you can show first that the statement complained of was or formed part of a statement on a matter of public interest, and secondly, the defendant, you reasonably believe that the publishing the statement complained of was in the public interest. Public interest isn't defined, but it's widely it's a wide concept, and it will include obvious things like detecting, exposing crime or serious impropriety, etc., etc., but more subtle things as well. The second part of the defense, which is that you, the defendant, have to show that you reasonably believe that publishing the statement was in the public interest, places the burden on the defendant, and much of this is really about showing that you behaved responsibly at the time prior to publication by seeking a response, for example, from the subject of the allegations prior to broadcast, and then fairly reflected that response in the program itself. Then we've got privilege. I'm not going to talk about this in too much detail, but as you probably know, certain things are privileged and can be published with impunity. So, for example, things said in Parliament, some statements made in judicial proceedings, that kind of thing. And then finally, I just wanted to flag this live program defense. So if, let's say, a guest on a live program makes an unprompted defamatory comment, the production company and the broadcaster may be able to avoid liability for that entirely if they can show that the statement was made in circumstances where they had no effective control over the person making the remark, and secondly, that they took reasonable care in relation to the production and didn't know or had no reason to believe that they were contributing to the publication of the defamatory comment. And that's a complete defense, no matter the truth or falsity of the remark. So if, again, if it's a talk show and a guest mouths off and says something appalling and defamatory, and provided the broadcaster can pass those tests, then it will have a complete defense. But it's important in this context, and I'm sure you've seen this before, that presenters take immediate action to distance the program or program maker or broadcaster from the remark, and that the remark isn't repeated. And that last point is quite important, because everything nowadays goes live, goes straight online onto streaming platforms. So worst case scenario, you fall flat on your face and you lose a defamation action, or you find yourself having to settle it because the claimant has the better case, or frankly because it's just too expensive to defend. So the remedies are damages. So for the worst allegations, of the worst allegations of, for example, terrorism or child sex abuse, awful things like that, damages can go up to, a couple of £100,000, possibly more. Obviously, the less defamatory, then you get less in damages. An injunction is a remedy that a court can give to prevent further publication of the allegations complained of. And then costs. And costs is, the big issue for defendants, because costs usually eclipse the amount in damages by some way. So that's defamation. So now we're going to move on to privacy, which, as I said, sort of it's a different right. There is some overlap with defamation, but as I always think of it as occupying a slightly different side of my brain. And privacy, as I sort of intimated earlier, is a balancing act. And on the face of it, it's extremely simple. We all have a right to privacy, which is enshrined in Article 8 of the European Convention of Human Rights, which we are still a signatory of, despite this government's best efforts. And that has to be balanced with the right to freedom of expression, which is enshrined in Article 10 of the European Convention of Human Rights. And this balance is neatly reflected in the test for misuse of private information, which is the law that we're talking about. And you know, the two questions that you have to ask, first, under Article 8, is there a reasonable expectation of privacy in respect of this information that we're talking about? And the types of information that usually engage right to privacy, you know, there are obvious things about people's health life, their sex life, things relating to what they say in private correspondence. But there are less obvious things as well. So recently, there was a case called ZXC in Bloomberg, which went all the way to the Supreme Court, in which it was held that the starting point is that a person under criminal investigation has, prior to being charged, a reasonable expectation of privacy in respect of information relating to that investigation. And you know, the idea that the fact of a criminal investigation engages your right to privacy has taken us a long way away from where privacy started over 10 years ago. And it sounds more like defamation. Your right to privacy is also less likely to be engaged if the information is already in the public domain, if it's not private, if it's been widely published before. So if there is a reasonable expectation of privacy in respect of the information you want to or you have published, the second question is, in all the circumstances, must the interest of the owner of the private information, so the person doing the suing, if you like, yield to your right to freedom of expression conferred on you, the publisher, by Article 10? And the court performs a balancing exercise, looking at the two opposing rights very carefully. And again, you know, public interest is widely construed. It has to be differentiated from what is interesting to the public, which is something else. You know, lots of things are interesting to the public but aren't in the public interest. And individuals relying on this tort of misuse of private information, they can seek an injunction preventing broadcasters from infringing their privacy, and they can sue for damages. And this injunction point, this pre-publication injunction point, is a key difference between the rights you have under defamation law and the rights you have under privacy law. If you went down to court as a claimant and said, I want to stop this program from coming out because they're going to say something defamatory of me, you're almost certainly not going to get an injunction because of the principle of you will have heard of this expression, publish and be damned. The courts consider that if the defendant says, well, I think these allegations are true, then they should be able to publish them, and if they get them wrong, pay damages later on down the line to vindicate someone's reputation. The case with privacy is different. If a claimant goes down to court and says, I've been told that, you know, this broadcaster is about to publish this private information about me, please can you injunct the program, they're more likely that, you know, they're much more likely to get an injunction than they would in a defamation case, because with privacy, essentially, once something that is private is published, the cat's out of the bag, and it's harder to remedy that. So that's one of the key differences. So where do we see privacy issues arising in our work? Well, first of all, there are documentaries. Obviously, if you are making documentaries that involve, mention, or otherwise feature real life people, then privacy issues may arise depending on the nature of the information. Fly on the wall programs is another common thing. So so-called blue light programs that follow, let's say, policemen and women, or doctors around. Obviously those kind of things may engage people's privacy rights, so you need to think about what you're doing there. Biopics, again, this is something that happens quite a bit, that we see quite a lot. So thinking of an example, let's say you were doing a biopic about celebrity X, and there was loads of information about celebrity X, about their life in the public domain. It's no longer private. You can use all that. But then let's say celebrity X's long lost brother contacted you and said, I've got loads of information, diaries that celebrity X kept when they were younger. I can tell you all about their problems with alcohol and the affairs they had. And let's say none of that was in the public domain, then obviously that can cause or will cause privacy issues, because celebrity X may have a claim for misuse of private information in respect of that information that his long lost brother provides you. And then the dramatic portrayal of true life crime. So crime dramas based on true life crime are all the vogue at the moment, and we deal with these quite a lot. And let's give an example. Let's say you want to make a drama series based on a series of violent crimes that were committed by person Y that took place a few years ago in, let's say, Hackney. And let's say the purpose of your show is to obviously entertain, but also illustrate in a dramatized form the problems with the criminal justice system. So the dramatic representation of person Y, his friends, families, associates, that might cause difficulties from a defamation point of view, of course, although less of a problem if they are no longer alive. But there's also a danger that you might intrude into the private lives of person Y's victims, and also potentially the victims' families, who would, of course, suffered enormous trauma as a result of person Y's crimes. And it's this second limb of the right to the misuse of private information that I was talking about earlier. The fact that privacy covers two things: not only keeping things private, but also not being subjected to unwarranted intrusion. So if actually producing your true life crime drama would be horrendously distressing for the victims of the family, the families of the victims and the victims themselves, assuming they're still alive, then that could infringe their rights to privacy. And this point is directly reflected actually in clause 8.19 of the privacy chapter of the Ofcom Code, which says that broadcasters should try to reduce the potential distress to victims and or relatives when making or broadcasting programs intended to examine past events that involve trauma to individuals, including crime, unless it is warranted to do otherwise. And critically, it says this applies to dramatic reconstructions and factual dramas, as well as factual programs. In particular, insofar as reasonably practical, surviving victims and all the immediate families of those whose experiences to feature in the program should be informed of the plans for the program and its intended broadcast, even if the events or materials to be broadcast have been in the public domain in the past. And that's under the suffering and distress paragraphs in the Ofcom Code. So to the extent that you're going to stick close to original facts, you'll need to think about approaching victims and their families at an early stage, assuming they're still alive, and their families, and get their agreement if you can. And they may often be willing to speak to you or contribute, for example, because they want to help you get your story across. But this obviously has to be handled with the utmost sensitivity. Note, if we're talking, still on the true crime topic, because as I say, it comes up a lot. If you're talking sexual crimes here, then the victims would be entitled to keep their identity private, not only under privacy law, because that is obviously information that is likely to engage their Article 8 right to privacy, but under criminal law too. It would be a criminal offence to identify them. So in order to avoid claims for misuse of private information and or committing a criminal offence, you'd need to be very careful not to identify those victims in any way or come close to it, unless that anonymity has been expressly waived by the victim. And there are ways of getting around these risks. So if actually the main point of your show is to illustrate in dramatized form problems with the criminal justice system, problems with getting cases to trial, for example, then you could reduce the risk by changing some of the features in your drama by, for example, setting it somewhere else in the country, changing other key facts and features, but whilst keeping, the original idea alive. So finally, I just wanted to say a few words on life rights, or so-called life rights, because under the UK law, at least, individuals do not own the rights to their own life stories. So actually, there's nothing to stop you making a film about a living individual's life, provided that you do so within the bounds of defamation and privacy law. Also, you want to try and avoid having to rely on the truth defense if you can, because having the defense in itself doesn't necessarily prevent an aggrieved person from bringing a claim anyway. And even if the claims are rubbish and meritless, it's expensive. It creates delays to your release schedule and general aggravation. So you can make yourself life easier, if possible, by getting the person involved, the subject of your show involved, and getting them to sign what's called a life story release. These get signed all the time. That it releases the production company or producer from any and all claims for defamation and privacy. The advantages of doing this, of course, are, it reduces the risk of future claims from the individual. It gets the individual engaged. So, you could be getting yourself some great access to personal information, historical records, interviews that hitherto weren't in the public domain. And all of that provides valuable insight on a creative level. Having an individual backing the project can also help with marketing and promotion, of course. But perhaps, most importantly, it provides comfort to financiers and distributors. They're more likely to provide finance if you have a signed release from the subject of the program. So that's it for my section. Thank you for listening.
Okay, so I'm going to have a look at some rights clearance issues now. And what do we mean by clearing rights? It's parlance that everyone commonly uses, but what does it actually mean? The way I like to look at it is if you think that everything that Leo's just talked to you about is largely, not exclusively, but largely addressing the rights that you need to be aware of that exist in respect of the content that you've created or the content that you own. Here, we're talking about other people's content and the rights that go with that content. They can come from a wide range of sources, and as we'll see, it covers a broad spectrum of material. The material that you want to include, be it props, music, whatever, will be physically owned by someone, but also there may well be underlying IP in it that you also need to consider. The most common right in issue here is copyright, and that's the one that we're going to be focusing on. On the slide, you get a very brief summary of what copyright is. It's essentially a monopoly right that allows the owners of the copyright not only to do certain things in relation to it, but more importantly here, to prevent others to do those same things without the copyright owner's consent. It's interesting, or it's important to note that it exists in this jurisdiction automatically. There's no sort of central register that you can go to see whether copyright exists in something. It arises upon creation and what's called permanent fixation. It can be assigned to third parties. It doesn't last forever, and the different types of copyright last for different periods of time. So it can be a bit of a minefield working out whether copyright does exist in something. If it does, who owns it, and what you have to do in order to get consent. Now, just stepping back for a minute, with the context of copyright, what we're looking at is broadcasting or copying a piece of copyright material and including it in your program and then broadcasting that program. Those are two acts which are restricted acts under the copyright legislation and which are therefore acts which are reserved to the copyright owner, subject to a few exceptions we'll talk about later. So in theory, at least, you're doing something which the copyright owner can prevent. Now, stepping back a minute and looking at things commercially, very often a copyright owner won't care that his or her work is being included in your production, and indeed will be very pleased if it is. It'll be a bit of free advertising. And as a result, there are some quite starkly different views between certain broadcasters as to the clearance processes that people have to undergo when considering material to be cleared to be included in a production. I'm going to be approaching it from the context of there is a potential issue in order to sort of talk through the relevant concepts that you have to consider. But I do acknowledge that, as I say, different broadcasters take different views as to what the level of risk that needs to be assumed and what people are required or are not required to do. I've listed there at the bottom of this slide the different types of work that are protected by copyright. Notice the question mark on the bottom bullet point of characters, which we'll come back to. And just going through quickly some of those in turn. Artistic works are a copyright work, a work that is protected by copyright. And so, as I say, in theory at least, if you're intending to include any of these works in your program and they're still in copyright, you're going to need the permission of the copyright owner to use them. Some are obvious, paintings, etc. Some are less obvious, badges and crests. Graffiti is another one that's commonly comes up. I mean, in theory, at least, as I say, that copyright exists in graffiti, which is an artistic work, and therefore, if you're filming graffiti on a set, you need to think about whether you need to clear the copyright in it, which obviously is not necessarily a straightforward process. Music, again, obviously a copyright work. There are three different sets of rights within music, rarely all owned by the same person. There is the sound recording copyright, which is the copyright that exists in the sort of physical medium on which the music is recorded. That's usually owned by the record label, assuming that the music you're using has been released on record or digitally nowadays. There is the compositional copyright, which is the copyright in the underlying song that has been composed, and there are two elements to that, both lyrics and the music. They will usually be owned either by the writer or his publisher. And then finally, there are performers' rights, the rights of the individual musicians who have played on the actual piece of music that you're reproducing. Usually those will have been owned by the acquired by the record label, but not always. So you need to check all of those various rights when you're including any piece of music. Obviously, featured music is included, but equally anything that's sort of sung or ad-libbed by an actor or a contributor. Ringtones as well, they're also music and they need to be cleared in addition. There are various other types of copyright work as well that need to be considered, and I've listed some there. But I just wanted to focus for a few minutes on the concept of characters because this is quite interesting and quite topical for copyright lawyers. Up until a few months ago, I would have said that there's no decision in England to hold that there is such a thing as copyright in a character. You can see, sort of stepping back, that there should be copyright in someone's literary creation if they've written a book, or copyright in a painting if they've painted it. But copyright in a character, that sort of sounds inherently or instinctively wrong. But there was a claim brought a few months ago by a company called Shazam Productions Limited, which essentially owns the intellectual property of John Sullivan, who wrote the scripts and devised the very popular television series Only Fools and Horses. The claim was brought against some people who ran what was known as an interactive dining experience. People were allowed to buy tickets to go and have dinner somewhere, and at the event there will be characters dressed up as the various characters from the programme, Del Boy and so on, Rodney, Uncle Albert, etc. And they would interact with the diners. They would quote some lines from some of the scripts from the series. They would act out their role play. Del Boy would be saying "lovely jubbly" all the time. He'd be using French in an incorrect way, etc., etc. And the owners of Shazam Productions, essentially the heirs of John Sullivan, took exception to this and brought a claim. I mean, in short, the claim succeeded. It succeeded in a number of respects, but the interesting one here is that the judge held for the first time, as I say, in England, that as well as the copyright in the script being infringed, they'd also infringed the copyright in the character. The judge held that the Del Boy character was a well-rounded character with sort of distinct delineations that could be identified, and the use of him, even in a sort of an entirely new setting, even if they hadn't ripped off large parts of the scripts of the individual episodes, which the judge held that they had, even if they hadn't done that, and they just sort of interposed Del Boy in a new setting but kept his distinguishing features, that would have been an infringement, or was an infringement of copyright, because there is now copyright in a character. As I say, that hadn't been held to be the case in England before. There was a case in, I think, Germany involving the character Pippi Longstocking, but this is a first for UK law at least, and that raises interesting questions. Some of which can be absurd. If you think of a well-known character in a current film or television series, Terminator or Arthur Shelby, for example, or anyone, if you put them in an entirely new setting, write a completely novel script with a new plot line, etc., one would have thought perhaps that wouldn't get you into difficulties, but now as a result of this case, you're going to have to think about the copyright in the individual character as well. So having sort of looked at what copyright exists in, let's have a look at some instances where you don't need to clear copyright, where it's not of a concern. It's an infringement of copyright to copy the whole or a substantial part of the original work in question, be it a film, a book, a piece of music, or whatever. So by definition, if you don't copy a substantial part of the original, you're not even in infringement territory. That's helpful insofar as it goes, but the legislation that says that then doesn't go on to define what a substantial part is. One thing that's clear, it's not a quantitative test. There is a qualitative element to it as well. So if, for example, you lift some music from a song and say, well, I've only taken one line, that can't possibly be copyright infringement because it's not a substantial part. It's only 5% of the lyrics and the music. That's not going to get anywhere if it's the main hook or the riff that you've taken, the most memorable part of the song. So it's not a straightforward sort of counting exercise. to work out whether what you've copied is a substantial part or not. Another very useful tool, I've described it here as your best friend. For those of you who are wondering, that's a picture of two best friends having a hug by the seaside. Is what's called incidental use, section 31 of the copyright legislation. Copyright in a work is not infringed by its incidental inclusion in a blah 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 film or a broadcast. So you can include copyright material incidentally without getting into infringement territory. Again, so far so good. That's what the legislation does. Once again, what it doesn't say is define what incidental means. The case law has determined that it's fine if it's fleeting or momentary. Equally, it's not fine if it's prolonged, repeated, the camera lingers on it, the dialogue draws attention to the copyright work in question, etc., etc. It can never apply to music. You can never argue that incidental music is incidental. That's essentially a product of the success of the music industry's lobbying when the legislation was first introduced. Something else important and helpful to note is that it's incidental, not accidental. So you can deliberately include something on set. You can put a prop in shot, and it can still be incidental, even if it's deliberately in there. The example I often give, which is semi-amusing in this instance, was a claim we had for a few years ago, and I can talk about it because it was reported in the press. We do a lot of work for Kudos, who make Broadchurch, and in I think series 2, the plot line involved a rape, and one of the suspects was a character played by Lenny Henry, and there was some filming in the home which was supposed to be Lenny Henry's character's home, and the owner of that house happened to have a painting of a cockerel on his wall, and the relevant production personnel looked at it and thought, that's fine, we'll just include that, we'll leave it in there, no point taking it down. And then the camera in shooting in the set panned round, as one would, caught Lenny Henry's head in shot, and then as it passed through also caught a fleeting glimpse of this painting of this cockerel. I think when I looked at it at the time, it barely even crossed my mind. I just took it as read that was incidental use, until we got a letter of claim in from the artist who painted the cockerel, saying that this was an infringement of her copyright. To which we responded saying, no, section 31, incidental use, etc. She then came back with a rather novel and ultimately unsuccessful argument that no, it wasn't incidental. This was deliberate inclusion. As I say, that's not the test. But she said, you're in a rapist suspect's house and you've got a painting of a cock on your wall. That's deliberate. I'm not quite sure where you go with that, but that was the argument she raised. Here's a couple of slides, sort of at two ends of the spectrum, to make the point. Not entirely sure how helpful they are, but slide 1 here, incidental use ? Answer no. If you came to me and said, do I need to clear these paintings here that these students are copying? I would say no. Their background, they're not featured, you can barely see them, etc. Compare and contrast with this one. Yes, you should clear that, assuming it is in copyright and the copyright hasn't expired. Another of your best friends is section 62 of the copyright legislation. This provides that buildings or works of copyright that are permanently on display, you're allowed to film them without clearing the copyright in them. If you work on the basis that every building and the design of every building attracts copyright, skyscrapers, the Shard, the Gherkin, etc., etc., it'd be a nightmare and practically impossible to do any location filming if you needed to run off and get copyright clearance. But my amusing anecdote here was a film called 24-Hour Party People that we worked on a number of years ago for a client, Revolution. That concerned the sort of Manchester music scene in the 1980s, which centred around the club, the Hacienda, which is now burnt down. And when the producers wanted to recreate the set, what they did, unable to film at or in the Hacienda, they thought they were being very, very clever, and they went to the local library and got the plans out of the library, and they basically built a new Hacienda club based on those plans. And then lo and behold, we got a novel, perhaps, claim for copyright infringement in from the architect, saying that we'd infringed the copyright in his plans by recreating the building. That's quite, as I say, that's quite a novel argument. It settled in the end, so we never resolved it. But it's somewhat ironic if you think that we could legitimately have filmed the outside of the building with no problem at all, without consulting the architect at all, by virtue of this provision, and yet we needed to get his consent by rebuilding it. There's a question mark on the next slide. It's a question for you. There's no obvious or clear answer. I say that you don't need to get copyright clearances in relation to buildings or works that are permanently on display. There's the fourth plinth at Trafalgar Square. Obviously that was, I don't know if it still is, a sort of revolving display for copyright works that were there for periods of time. Whether that is or was permanently on display, and therefore you could film it without getting clearance, is a question I pose for you. Okay, so let's have a look at fair dealing now. So the examples I've just given you, section 31 and section 62, are instances where you're not infringing copyright. You don't need to come up with a defense to a copyright claim because you're not infringing copyright. This is a bit different. This is a situation where you want to include a copyright work, you want to feature it heavily and non-incidentally. It's not a building that you can film outside, so you need to find another way of getting it into your production without consent from the copyright owner. And it might be that you can't find the copyright owner, it might be that you don't want to ask them because you know that they'll say no, or, as we'll see, you may have asked them and they've said no, and you want to know whether you can still include the material. There are a number of limbs to fair dealing, and it's not necessarily that straightforward. I'll try and take it in stages. There are, if you like, 5 what I call gateways through which you can get into a fair dealing defence, and I've listed them there: reporting current events, criticism or review, quotation, parody, caricature or pastiche, and research and private study. So if you fall within any one or more of those gateways, you've then got a potential fair dealing defence open to you, and we'll look at later on at the other sort of limbs of the defence that you also need to satisfy in order to make sure that you're not infringing copyright. I'm not going to go through all of those gateways, and in fact I'm not going to look at current events, which is mainly used in the sort of the news scenario. Worth noting there, though, that photographs can never be used in fair dealing when relying upon the current events gateway. So let's have a look at criticism or review in a little more detail. This is one of the most well-known gateways, and it's most commonly found in factual programming. I mean, its origins stem back to the sort of olden days when a newspaper, a print newspaper, would want to review a play that had been on in the West End the night before, or a book that had just been published, and they wanted to perhaps quote from the work and say what they thought of it. And if they did that by relying on this defence, subject to the other limbs of it, they were held to, they were okay if they criticised or reviewed it. those are the origins of the defence. It's been stretched over time, so much so that there was a case 20 years ago now, probably perhaps longer, brought by a paparazzi photographer called Jason Fraser. What happened there was a program maker wanted to make a film, a TV program rather, about the world of the celebrity. And they approached Jason Fraser to use lots of his paparazzi photographs, largely of the Beckhams, in the program, and he said no, or if he said yes, it was for a fee that was deemed unacceptable. So instead, they decided to fair deal his works, and the program largely consisted of lots and lots of his photographs reproduced with some commentary over them. And the way that the defence succeeded was that there would be a shot of Victoria Beckham stepping out of a car, for example, ostensibly a paparazzi shot. But the voiceover explained that actually, if you looked at it carefully, it wasn't a pap shot. What the practice that the Beckhams were adopting at the time was, in order to have some peace and quiet on their 2-week holiday, they'd invite the paps in to do a photo shoot on day one of their holiday, on the premise or on the understanding that they'd then be left alone for the rest of it. And this is the sort of culture that the program was exploring, and it used lots of Jason Fraser's photographs to sort of make good the point. And in large part, the defence succeeded. It didn't succeed in every instance, but in large part it did. So that sort of shows the extent to which the defence has, as I say, been stretched. So much so that you don't need to criticise or review the work in question. You can actually criticise or review another work. So if, for example, you include a clip of a film and you criticise or review the film, you can also include the soundtrack from the film in the same clip without getting clearance or criticising or reviewing the soundtrack. You don't actually have to criticise or review the work. You can criticise or review the underlying theme or the ideas expressed by the work. So you might show lots of clips of gangster films, for example. You won't be reviewing the quality of the directing or the quality of the acting, but you might explore the concept of gangland warfare and use those clips as a means of illustrating the theme that you're talking about. A couple of other limbs of the defence, which apply, this one applies to all the gateways. The work has to be publicly available, so it already has to have been out there in the public. If it's a new work that's never been released before, you can't fair deal it. There also has to be what's called a sufficient acknowledgement, essentially a credit, for both the title of the work and its author, noting that the author might not necessarily be the current copyright owner. Remember, I said before that copyright can be assigned. The sort of safest legal way of giving sufficient acknowledgement is to super those lines on screen at the time when the work is being shown. However, I'm well aware that creatively that is resisted, and my view tends to be, and the advice tends to be, that it's usually okay to include those lines in the end credits, so long as you make them sufficiently clear and obvious. Another limb of the defence, which I put up on the slide, is that the use has to be fair. We'll come back to that. Quotation is another gateway, as I'm calling them. It's relatively new, been around for 8 years, and as a result, there's not a huge amount of case law on it. The main benefit for using this gateway is that you can use a quotation, think clip, from a copyright work without having to criticise or review it. So the example is, for example, a television program might be interviewing an actor, and they might want to show clips from his recent films. They're not going to criticise or review the films. or even the ideas or the themes behind them, reference the gangland example I gave a minute ago. They just want to put them up there because it looks nice to have them in the background whilst the actor is being interviewed. So long as they do it right, they can rely upon the quotation gateway of the fair dealing defence. Again, it's got to be a publicly available work. It's got to have been out there already. The quotation or the clip used must be no more than is required. Query exactly what that means, and it's open to argument. Creators will say that they need a lot and explain why. Generally, safest to err on the side of caution, because, again, as I'll talk about in a minute, the use has to be fair. So don't pepper your program or your film with huge long quotes or extracts or clips from copyright works and then try and rely upon the quotation defense. That's not going to get you home. One question, which again I pose and don't answer, in theory, the quotation defense is available to all the various different types of copyright work that exist. Query how you quote from a photograph or quote from some artwork. Does that mean you only show a little bit of it? Again, as I say, asking the question and not giving you the answer. Let's have a look at parody, caricature, and pastiche. I always struggle to say that, so I'm going to shorten it to PCP. Again, relatively new, available since 2014. And again, the Shazam case is relevant here because the makers or the inventors, the creators of the dining experience argued, well, firstly, they weren't infringing copyright. They hadn't copied the scripts, and there was, they said, no copyright in characters, so they weren't infringing copyright. But even if they were, and even if there was copyright in characters, they said that they benefited from the PCP defense. This was a funny experience. It made people laugh. It used the quotes and the lines that Del Boy and Rodney used in the TV series. The judge wasn't having any of that. He said that for parody to succeed, the new work must constitute an expression of humour or mockery, i.e., it itself had to be funny, rather than simply just mimic or copy the original work. And again, pastiche failed because there was no element of imitation. The judge said it was basically a reformatting of the TV series in a dining room setting. Again, the use has to be fair, which I'll talk about in a minute. Helpfully here, there's no requirement for sufficient acknowledgement if you come within the other limbs of the gateway. Amusingly, one of the things that probably did the dining experience down when they were arguing that their dining experience work was sufficiently different from the original, such as to amount to PCP, were some quotes from the audience, which the dining experience had very sensibly, on one level at least, put on their website. Quotes such as, "Great night out, felt like we were in an episode of Only Fools and Horses." The judge relied upon that, I think, when making his decision. And then finally, on fairness, as I've been saying, even if you get into one of the gateways of the fair dealing defence, there's a sort of overarching element that you have to satisfy, which is of fairness. The only purpose that you're using the copyright work must be fair dealing. Fair enough. You're unlikely to succeed in fair dealing if the work in question, your work, competes with the original, and in particular if it's commercially going to affect sales of the original. Again, something that did the dining experience down was that at the time they launched their product, there was, I think, a live musical version of Only Fools and Horses being exploited or about to be exploited. So again, the judge thought that the use wasn't fair. Are you using more than is required? As I referenced earlier, less is more in this in this situation. And again, the dining experience fell down on that element as well. Their work was peppered with lines from the scripts, etc., etc. Note, you shouldn't use any fair dealt materials in any of your trails or your publicity materials. Don't advertise your product by use of the fair dealt material. That's not going to be deemed to be fair. And then finally, do you need to notify the rights owner? Well, the short answer is no. You either fall within the fair dealing defence or you don't. And if you do, then by definition, you don't need the consent of the owner. And usually it's best not to notify them, so as not to give them prior warning and a chance to object, threaten a claim, etc., etc. Another question we get commonly asked is, we've asked, they said no, can we use it anyway? Well, in theory, yes. What you would need to do is to demonstrate that having asked and been told no, the way that you then used the material came within the fair dealing defence. So it might be that your paper trail shows that you were planning to use the work in a particular way. You asked for consent to that, you were refused consent, so you changed the way that you decided to use it, and instead took advice and adapted your use of the work such that it came within the fair dealing defence. Nothing wrong with that. So that's all I've got to say. I hope this has been helpful and useful. If anyone does have any questions having watched it, do feel free, please, to get in touch either with me or with Leo or anyone else at Lee Thompson. And there we go. Thanks very much.